Miss Hennigan, you have Mr. Tetters.
Yes, Your Honor, and that's with Sarah Brenner.
I'm here.
Yep, I see Sarah Brenner.
Hi, Sarah.
Morning.
Your Honor, if I could have a breakout room with Miss Brenner, that'd be awesome. Please.
All right, Miss Brenner, do you have any objection? I don't usually do breakout rooms on Zoom on Wednesday mornings with a prosecutor, but Miss Brenner, is that all right?
That's fine.
File. PQ. Miss Adams?
Yes.
I don't think I have the Tetters file.
Oh, you know what? I don't think she brought it to me. Let me go get it.
Okay. All right, this is, let me find Mr. Tetters. There he is. All right, this is in the matter of the people of the state of Michigan versus Kenneth Charles Tetters. File number 2023-21265FH. I have Tamaris Hennigan appearing on behalf of the defendant. Miss Hennigan, what's your P number, please?
P81968.
All right, and Miss Brenner, Sarah Brenner, appearing on behalf of the Attorney General. Can I have your P number, please?
65430.
All right, this is the date and time scheduled for arraignment in this matter. To start with, Miss Hennigan, do you waive the reading of the felony information?
We do, Your Honor.
Have you received a copy of the felony information, witness list, and request for discovery from the Attorney General?
Yes, Your Honor.
Okay, so you're asking for a breakout room at this point. So I'm gonna open up a bunch of breakout rooms and I'll give you a few minutes. As I said, I usually don't allow attorney breakout rooms on Wednesday mornings just because we have so many people to move through. But there you go. Go ahead and join that breakout room, Mr. Tetters. Just bear with us for a moment.
Okay.
And Miss Adams, if I could get the jail and let's see what I got. I got Miss Van Duzen. Could I get Milton Rembert or John Dodson to begin with?
Okay.
Mr. Coast, what case are you hearing? Dodson and
Two today,
Very
Judge Christine Kramer and Mr. Dotson.
okay, thank you. Ms. Hennigan and Ms. Brenner. All right, so Ms. Hennigan, how do you wish to proceed today with Mr. Tetters?
Your Honor, I'll have my client enter a plea of not guilty this morning.
All right. So I'm going to enter a plea of not guilty on behalf of Mr. Tetters, and I will set this for another pretrial on April 26th at 8:30 in the
Your Honor, that was what I talked to Ms. Brenner about before we came back in with you, but if it pleases the court, we would like to ask for our pretrial to be put out 90 days. Mr. Tedder started a new job and cannot miss any work for 90 days, or he'll point out he can only get 2 points in his probationary period. And Ms. Brenner agreed that that would be okay with her.
That's
All right,
correct.
I
Your Honor.
will set a pretrial conference for June 14 at 8:30 in the morning. Because it is an arraignment today, my staff will do the notice of hearing. So June 14 at 8:30 in the morning for a pretrial conference.
Thank you, Your
All
Honor.
right, so Mr. Tedders, we'll see you back on that day. Thank you.
Very
Thank
much,
you.
Your Honor.
Thank you. All right, I'm gonna guess you look like an officer from somewhere. Can I ask where you're calling from?
Monroe County, about to pass this on to Tasha Champagne.
Who do you have?
Tasha Champagne.
Spell the last name.
Judge, we have her down as Vinton. It's also AKA Champagne.
Okay, all right, that is Miss Underwood. All right, so I'm going to put that in there. Miss Van Dusen, is there any way, this is an arraignment, and obviously it's it's a probation violation arraignment, never mind. All right, so ma'am, do you go by Champagne or Vinton now?
Champagne, Your Honor.
Okay, can you spell that?
CHA, M as in Mary, PAGN as in Nancy, E.
All right, so let me grab your file.
You done, you bring that to party? Thank you.
All right, this is in the matter of the people of the state of Michigan versus Tasha Renee Vinton, also now known as Champagne, file number 20-19844FH. All right, so, ma'am, we are here today. Look through here because I got some documents from you. Let's see, incarceration. So we are here today on a request and warrant for probation violation, ma'am. There are multiple counts. One alleges that you left the state and were in an accident that was documented in Tennessee on or about June 18th of 22. Second violation alleged is that you failed to report as instructed on June 30 of 2023. The third allegation is you failed to notify your agent of any police contact within 24 hours, and that would be referencing that accident. And the fourth violation is that you failed to be in your approved residence during your curfew hours on June 18th of 22, since you were in Tennessee. So ma'am, those are the allegations against you. Do you understand that?
Yes, Your Honor.
Okay, so you're currently on probation. Let me find it back here. Well, you're on controlled substance possession of cocaine less than 25 grams. Looking for your felony information, which for some reason I can't find. So hold on a minute. So that carries, ma'am, if you plead guilty or are found guilty, do you understand that carries a maximum penalty of up to 4 years in prison? Do you understand that?
Yes, Your Honor.
Now, Ms. Vinton, you do have the right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire an attorney, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes, if I could, Your Honor.
All right. Ms. Van Dusen or Mr. Malaro, would either of you be able to talk with her briefly?
Yeah, I can, Your Honor.
Okay, so, hold on a second. Miss Adams, could you bring me my cell phone?
Okay.
I'm sorry, I got it. A second. Right, Ms. Van Duzen, we will email it to you, but I did just send you a screenshot of the violations. So Ms. Champagne, I'm going to put you and Ms. Van Duzen into a breakout room. And all right, so and Ms. Van Duzen, thank you for doing that. Okay, just open that breakout. All right, and who do I have from the jail?
John Dotson.
Okay, Mr. Dotson, just bear with us for just a moment.
Can I say something?
Well, you have an attorney, so I want you to wait for your attorney, okay?
I was saying I need help.
Say it again.
I was saying I have a drug problem and I need help.
Okay, well, yep, so give us just a moment and we'll get your attorney back.
Okay.
All right, so. Continue. All right, Mr. Foster, you want to come up to the podium, please? All right, Mr. Foster, thank you. This is in the matter of Rebecca Foster versus Glenn Lott Foster, file number 2022-50173 PP. Mr. Glenn Foster is present in the courtroom. This is a date time scheduled for a petition for order to show cause. Mr. Hyatt, and I do show that that was served upon you on February 14th of 23. Now, sir, it is alleged that you have violated the terms of the PPO that is in effect until June 8th of 2023 by sending mail or other communication to the petitioner on or about December 14th of 2022. Do you understand that's a violation against you?
Yes, sir.
Okay, so Mr. Foster, a violation of a personal protection order can carry up to 93 days in jail and a fine. Do you understand that?
Yes.
Now, you do have the right to have an attorney represent you here today and in future hearings. If you can't afford to hire one, we can appoint one at public expense. Would you like an attorney appointed to represent you?
I have a more serious allegation set for a pretrial on March 16th for a assault charge against the same woman. I was wondering if my current defendant for that category, I won't be able to
Say that again. So
Okay.
you have pending charges downstairs?
yes.
And what did you say after that?
My current defender, Katerina Dumont, I was wondering if she would be able to defend.
On this?
Yes.
Okay, so Ms. Dumont works mostly in the district court level. We can appoint an attorney and are you able, Ms. Adams, can he come back tomorrow morning or Friday morning?
Being judged. So you have an 8 o'clock adoption and drug court and jury trial currently scheduled tomorrow.
What about Friday?
Friday, you have 9, I believe, sentencings, 9 o'clock, 11:30.
Yeah, we're gonna
What's the
take,
next?
we're
What,
taking
Miss-
care of the
Miss
trial
Van-
for tomorrow.
I'm sorry, Ms. Van Dusen, say that again.
We're taking care of the trial for tomorrow on busing. That's not going.
Okay, well, Ms. Van Dusen, as chief, assistant chief public defender, I have Mr. Foster here on a violation of a PPO. He has a related charge down in district court and Ms. Dumont is his attorney. And he was wondering if Ms. Dumont could be appointed to represent him on the violation of the PPO. And I
Yes,
could set this over to another day. Is that permissible?
yes, if it's not this week, due to the fact that her grandfather died.
Okay, all right. So Ms. Adams, when would be a day for next week? We could bring him back.
Mm. Eight AM, March 14th.
All right, March 14 of 23 at 8 AM. And sir, I'll put that in person. Could I get a notice of hearing for him, please, Ms. Adams?
Okay.
All right, and then we'll make a note on there that he requested Ms. Dumont, all right? All right, so Mr. Foster, have a seat on the bench behind you. I'll enter a plea of not guilty on your behalf. Yep, right there. And then we'll have you back on March 14th at 8 AM in person and see if Ms. Dumont will be able to be here. And remember, the PPO remains in effect, so I don't want to see any violations, all right? Okay. Mr. Casillas, your attorney is here. You want to come on up? All right, so Ms. Van Dusen, back on the record in the matter of the people of the state of Michigan versus Tasha Vinton. Have you, or Champagne, have you had an opportunity to speak with her?
Yes, Your Honor.
All right, and how would you like to proceed today?
She's going to plead guilty, Your Honor.
So Ms. Vinton, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Have a seat. Just sit down. It'll just be a minute. I'm sorry. All right, Ms. Vinton or Ms. Champagne, now you would ask for court appointed counsel. We appointed Ms. Van Dusen to represent you. Are you satisfied with Ms. Van Dusen as your attorney and the advice that she's given you?
Yes, I am, Your Honor.
All right, and you understand that you do have a right to contest the violation of probation charge and to have a trial in it. Do you understand that?
Yes, I do.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, I do.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
I do, Your Honor.
All right. You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, I do.
Okay. Mr. Foster, you're all set. So we'll see you back next week. On the other hand, ma'am, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
Okay. So, Ms. Foster, or I mean, Ms. Champagne, how do you plead to the charge that you left the state of Michigan and were in a documented accident, I'm assuming a car accident in Tennessee on or about June 18th of 2022? Guilty or not guilty?
Guilty, Your Honor.
And how do you plead to the charge that you failed to notify your probation officer of any police contact within 24 hours of that accident? Guilty or not guilty?
Guilty.
How do you plead to the charge that you failed to report as instructed by June 30th of 2022? Guilty or not guilty?
Guilty, Your Honor.
All right. Now, how do you plead to the charge that you failed to be in your approved residence during your curfew hours on June 18th of 22 as you were in Tennessee? Guilty or not guilty?
Guilty.
All right. All right. Do you understand that by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes, I do, Your Honor.
Has anything been promised to you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, they haven't.
All right, if I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do.
Okay, is it your own choice to plead guilty?
It is, Your Honor.
All right, so ma'am, you were placed on probation. One of the terms of your probation is that you are not to leave the state of Michigan without permission of the probation department. Is that correct?
Yes,
Okay, now on June 18th of 2022, were you in an accident in Tennessee?
yes, I was.
Okay, and did you report that? And I'm gonna assume the police were involved. Did you notify your probation officer of that police contact within 24 hours?
No, I did not, Your Honor.
All right, since you were in Tennessee, you weren't in your approved residence during your curfew hours, is that correct?
That's correct.
And then you failed to report by June 30th, is that correct?
That's correct also.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. Ma'am, do you mind if I ask why you're in Monroe County Jail?
I also have a violation from the same incident. I was on probation, through a couple different courts, so.
Okay, all right, so, Ms. Adams, how long will we, so ma'am, do you have any objection to appearing for sentencing via Zoom?
No, I do not, Your Honor.
All right, so Ms. Adams, how long would I need, to be able to set up a Zoom meeting with her for sentencing? Can I do that in a week or?
Should be, we set this up last week, so it should be fine.
Okay, so what, all right, so I'm going to set this matter for a violation of probation sentencing on March 17th of 2023 at 8 a.m. Now, Ms. Walsh, I got the wrong screen name for you. I don't know why I did that. You can change that, you know.
I can be John.
Well, I changed John's name and I actually changed yours, sorry. So Ms. Walsh, will contact you, Ms. Champagne, and if she may, do you want to talk to her this morning?
Yes, please. Otherwise, I won't
Okay.
be able to.
Yeah, she's gonna talk to you this morning. She'll do a pre-sentence report. We'll get that to your attorney and we'll see you back on March 17th of 2023 at 8 a.m. via Zoom for sentencing. And let me open that breakout room. And Ms. Champagne, we'll see you back on that day, all right?
Okay, thank you, Your Honor.
1 second. All right, Ms. Champagne and Ms. Walsh, you should receive an invitation to join a breakout room. Ms. Van Duzen, you represent Mr. Dotson, is that correct?
I do, Your Honor.
All right, so
Yeah.
yeah, hold on, Mr. Dotson. So this is in the matter of the people of the state of Michigan versus John Anthony Dotson. We have 3 files, 2020-19905FH, 2022-20897FH, and 2023-21216FH. I have Dawn Van Duzen representing Mr. Dotson, and I have Isaac Sneed appearing on behalf of the people, and I have Darren Coast appearing on behalf of pretrial services. Ms. Van Duzen, how do you wish to proceed today with Mr. Dotson?
Your Honor, in this matter, it looks like one of the files that you have in front of you, the 23, is actually a pretrial April 5th. We do have a plea agreement, but it looks like there'll be charges. There's charges going to be submitted once the labs come back. So I'd ask that we put it to the April 5th day. The offer is as charged as an R&O, and then in the other file to use some math. And if they do submit, it'd be an attempt on that one. So I'm asking the court to put it over to April 5th, take off the jury trial in the 2220897 file. At that time, I do pretty sure we will have a plea at that time.
All right, any objection to that, Mr. C?
No objection, Your Honor. Thank you.
All right, so Ms. Adams, we will remove that jury trial date. And that was on the which file?
It's on the 2220897 and it's scheduled for April 11th.
Okay. Okay. All right, so we will take that jury trial off the books. We will set all three of these over to April 5th at 8:30 in the morning. Ms. Van Duzen, I do believe you're in a breakout room, but Mr. Dotson did express on the record that he's looking for assistance with his substance abuse issues. So Mr. Dotson, that will get addressed as part of your file. And
Yes. He is not qualified for drug court.
That's not
No,
what I need rehab. I need rehab. I have a drug problem, obviously,
But-
and I need help.
we can still address those issues through any probation if he receives probation. So, all right, Mr. Dotson, you're all set. Thank
Wait,
you.
what's that mean? I gotta wait, I gotta be in here all the way till when?
April 5th at
When is
8:30 in the morning. All right,
Alright.
thank you. Thank you, Mr. Dotson. All right, Mr. Puda, there you are. Mr. Puda. All right. So this, you can step back. Oh, thank you. So this is in the matter of the people of the state of Michigan versus Juan Diego Loera Pacias. This, and I have Attorney Julian Puta appearing on behalf of him. Sir, what is your P number, please?
P67520. My name is Julian Food on behalf of the defendant.
Something is
Okay,
going, can I ask something? Would I be able to?
no,
get a
we're
bond?
done with you now, Mr. Dotson.
Would I
Go
be able
on
to get a
back.
bond?
All right, thank you. All right, so, and I have Isaac Sneed appearing on behalf of the people. This is the time set for pretrial. Mr. Puta, how would you like to proceed?
Your Honor, we do have a plea agreement that we've reached.
All right, and what is that agreement?
It's the defendant, my client, is going to be pleading guilty to count 5 misdemeanor assault and battery of Travis Ritchie.
We don't use victims' names on the record. We only use initials.
Pardon me?
We don't use any victims' names on the records. We only use initials. It's a new change in the court rules.
Okay, so Your Honor, my client be pleading guilty to count 5 misdemeanor assault and battery of TR. And the prosecutor is agreeing to dismiss all of the other charges in the information without prejudice. And there's additional terms and conditions of the plea. There's actually a written document. I could read it into the record as far as it's a Killebrew agreement.
All right, hold on a second. I'm trying to write all this down. Okay, what are the terms of the Killebrew agreement?
Dismiss all of the other charges without prejudice.
If I could interject, Your Honor, I did just email this document over to Miss Adams. It may help for her to print it off and bring it to the court because there are about 6 paragraphs. Excuse me, about 8 paragraphs of terms.
Okay. Ms. Adams, do you want to forward it to me or?
I'm printing it right now, Judge.
Ms. Van Duzen, I have Rob Van Horn, Kelsey Quinn, Travis Loomis. Any of those yours you need a breakout room with?
Did you see Van Horn?
Yeah, do you need a breakout room?
Van Horn's mine, Judge, and we're ready to enter a plea on that.
Okay,
Okay, so I have now received a copy of the plea agreement. All right, so it states that he will plead guilty to count 5, assault and battery. All other charges will be dismissed without prejudice. He'll enter his plea before March 8th, forfeit Smith and Wesson, no contact with TR. A 93-day jail term, which will be suspended as long as he complies with the terms of probation, 2 years probation, no early discharge, engage in successfully complete anger management, no contact with AL, not to purchase or possess a firearm. If successfully completes probation, will be discharged and the remaining dismissed charges will not be refiled. If he does not successfully complete probation or there is a material violation, he will be ordered to serve 93 days in the jail, and the prosecutor's office reserves the right to reinstate the additional felony charges and prosecute to the full extent of law. Right, so is that the summation of the agreement, Mr. Sneed and Mr. Puda?
Your Honor, with respect to the no contact with the individual with the initials AL, we had included except with respect to parenting time provision. Otherwise, everything else is accurate.
I would agree with that, Your Honor. If you could, subparagraph 4 of paragraph D, it should read, defendant shall have
Okay,
no.
it does say that, I just didn't read it. Okay. Okay. All right, so. So, Mr. Loera Pacius, want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so Mr. Loera Pacius, you've heard the plea agreement that was placed on the record, is that correct?
Yes.
All right, and is it your intention then to plead guilty to that count 5? I think it's count 5. Count 5 misdemeanor assault and battery, which carries a maximum penalty of up to 93 days in jail. Is it your intention to plead guilty to that?
Yes.
All right, so bear with me. I have a double ear infection and a sinus infection. So are you satisfied with your attorney and the advice that he has given you?
Yes.
All right. There's been an agreement placed on the record and you reviewed that with your attorney
Yes, I did.
and you fully understand that
I
agreement?
fully understand that.
Okay. Now, pretty much that agreement discuss any possible sentence you would be receiving. Do you understand that?
Yes.
All right, so if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, I read them.
Okay.
Over and over.
Okay, so how do you wish to plead to the charge that on or about March 2nd of 2022 in Raisin Township in the county of Lenawee, that you did commit the offense of assault or assault and battery? Guilty or not guilty?
Guilty.
Okay.
Your Honor, may I voir dire my client for the factual basis?
Well, I haven't gotten there yet, so I'll let you, but let me get there. All right. Has anyone, other than what was placed on the record, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Okay. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I don't understand.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than what was listed in the plea bargain to induce the defendant to plead guilty? Mr. Puta,
No, Your Honor.
Mr. Sneed.
No, Your Honor.
So you understand there is a very detailed agreement about what your sentence will be.
Yes,
Okay. Is it your own choice to plead guilty?
yes.
All right. So Mr. Puta, you can voir dire.
Mr. Lorea Pasillas, I'd like to direct your attention back to March 2nd of 2022. Were you in the city of Adrian, County of Lenawee on that date?
Yes,
And did you put an individual with the initials TR in fear or apprehension of a battery by raising your fists up in the air?
yes,
Your Honor, I'm satisfied.
Mr. Sneed, are you satisfied?
Yes, Your Honor. Thank you.
All right, very good. Has court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, thank you, Your Honor.
Mr. Puta?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. There has been a very extensive agreement placed on the record, and understand that the court will follow that. But if the court chose not, you could always withdraw your plea, but I don't typically do that. So I'm going to refer this matter to the probation department for a pre-sentence investigation. Now, Mr. Loera Pasillas, you can appear in person for sentencing or via Zoom. So, but your attorney can also appear in person or via Zoom. So do you want to appear in person?
I like to be here.
Okay, do you mind, does your attorney, Mr. Puta, you can work out with him whether you're in person or via Zoom, all right?
Okay. Your Honor, would you consider immediate sentencing since we already kind of have all the terms and conditions?
No, it's a victim impact, and so I have to have a PSI.
Okay.
So I'm going to set this for sentencing on April 21st at 8:15 in the morning. Mr. Puta, are you available via Zoom that day?
April 21st at what time?
8:15.
Yes, Your Honor.
All right, so, Ms. Adams, could I please get a notice for Mr. Loera Pasillas?
Okay.
All right, so, and Mr. Puda, I have no objection if you appear via Zoom for sentencing, all right?
Okay. Thank you.
All right, you can work that out with your attorney. So I'm gonna mark that you're gonna be in person, okay? And, all right, so, Mr. Loera Pasillas, I'm going to refer this matter over to the probation, or no, I'm sorry, to district court probation for a pre-sentence report, okay? Because it's not a felony, I won't do the pre-sentence up here. So today is Wednesday, so tomorrow I need you to report to the district court on the first floor,
Okay.
their probation department between 8 and 10, okay?
Tomorrow?
Yes, can you do that?
Yes.
And then check in and tell them your name and tell them you're there to see a probation officer. We'll send the paperwork down and they'll set up a way to meet with you and to do the pre-sentence report. Be truthful with them about your background, the events that occurred. We'll provide a copy of that to your attorney. And then we'll see, so you can review it before sentencing, and then we'll see you back on April 21st at 8:15 in person, okay?
Okay.
So have a seat right there on the bench and we'll get you that notice of hearing, all right?
Thank you, Your Honor. Thank
All
you,
right.
Isaac.
Thank you.
Thank you, Mr. Puda.
Okay, so, hold on. Name, please.
Marley Blessing.
All right, Ms. Blessing. All right, hold on. Log. Ms. Van Duzen. Do you represent Ms. Bussing? Do you need a moment to talk to Ms. Bussing?
Yes, Your Honor, 2 seconds.
All right, do you want to you said you had a plea on Van Horn?
No, Mr. Malero has one on Van Horn. I will have one on busing.
Okay, so this busing, if you go out the door and you take a left, there's a Zoom unit right there on a stand. So why don't you go connect via Zoom, and that way I can put you in a breakout room with Miss Van Duzen. If you have an issue, just kind of pop back in. I'll have someone come out and help you, all right? All right.
Thank you, Judge.
Thank you. All right, so Miss Quinn, let me find your file. Mr. Malaro, do you need a moment with Mr. Van Horn?
I do not, Your Honor.
Okay, all right, we'll be with you in just a moment, Mr. Van Horn. All right. This is in the matter of the people of the state of Michigan versus Kelsey Leanne Quinn, file number 22-21168FH. I have Elias Mawad. What is your P number, Miss Mawad? Oh, I see it, 41632, appearing on behalf of Miss Quinn. And I have, who's my prosecutor? Phoebe Meir, appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Mr. Mawad, how do you wish to proceed?
Your Honor, I've talked to Ms. Meir and to Ms. Weiss. My client's going to be testifying and has been subpoenaed to testify in a preliminary exam on March 16th. Kelsey, can you unmute? Is that the date?
I believe it's the 17th.
March 17th. Can we get a date, maybe the first week of April, Judge, just to see where it goes and try to resolve it, or you tell me?
So my next available is April 19th. Would that work all right?
Yeah, I mean, Judge, I think that I was going to start a federal trial for 3 weeks, but I think that's getting adjourned. If there's an issue, I'll contact the court, but let's set it for April 19th.
I can do April 12th.
Well, let's do April 12th. Yeah, that's fine.
So we'll set this for a pretrial conference on April 12th at 8:30 in the morning.
Okay.
All right, so Ms. Quinn, we'll see you back here on April 12th at 8:30 in the morning. Anything else, Mr. Mawad?
Just want to let Ms. Quinn know she's been subpoenaed to appear, and Ms. Quinn, you know you have to be there on that date and talk to the prosecutors and cooperate. Okay, good. Very good. Thank you,
And it is
Judge.
the 17th at 10 for that exam.
Okay. Thanks, Phoebe.
Thank you.
Appreciate it.
Okay.
Thank you, everybody.
All right. Thank you. So Ms. Van Duzen, I am going to find you. There you are. I'm going to put you in a breakout room with Miss Bussing. Find her. Two. All right, so go ahead and join that breakout room. Mr. Malaro, grab Mr. Van Horn. All right, this is in the matter of the people of the state of Michigan versus Robert Lawrence Van Horn, file number 22-20925FH of Salvatore Malaro, appearing on behalf of Mr. Van Horn, and I need a prosecutor. I have Isaac Sneed appearing on behalf of the people. Let me find you in my paperwork. 1 second. Okay. And so this is the date and time set for pre-trial in this matter. Mr. Malaro, this matter is set for a one-day jury trial on March 14th of 2023 at 9 a.m. Mr. Malaro, how would you like to proceed today?
Today, Your Honor, we're going to enter a plea of guilty to count 1 under 74 and 11 and an amended count 3, a 90-day misdemeanor under 750.227D. And that's how we would like to proceed today.
All right, so he's going to plead to count 1.
Yes.
Under 7411. All right, and what is gonna, Mr. Sneed, I don't, or Mr. Malaro, I don't know what, I don't have count 3. So,
It's improper transportation of a firearm, Your Honor.
Mr. Sneed,
Yeah, it's MCL 750.227D. I just signed the amended information, Judge. It should be to you shortly.
all right, and it's a 93-day.
I believe it's a 90-day.
90 or 93, it makes no difference. I mean, in terms
Because
of
if you're in
what we're
jail
gonna
and you're
do.
gonna get out.
I'll bring it up here, Judge.
All right,
Once I sign something, I can. It is a 90-day.
okay, all right. Okay. And forfeiture of weapon involved?
Yes.
Yes, it's a 90 days and or $100 fine, mandatory forfeiture of the weapon,
All right, all right.
and a victim's rights assessment.
Okay. All right, Mr. Van Horn, you want to raise your right hand for me so I can see it on the screen? Thank you. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so you've heard the statement of your attorney. Is it your intention to plead guilty to count 1, controlled substance, possession of methamphetamine under 7411, which means that if you successfully complete probation, it'll be off your record, as well as an amended information adding a count 3, improper transportation of a weapon, which is a 90-day misdemeanor. Is it your intention to plead guilty to those 2 counts?
Yes, ma'am.
All right, do you understand the maximum penalty for possession of methamphetamine could be up to 10 years in prison? Do you understand that?
Ma'am.
Okay, now, Mr. Van Horn, are you satisfied with your attorney and the advice that he has given you?
Yes, ma'am.
Okay, all right, so I'm gonna pause for a minute and take about a 2-minute recess, and I'll be right back.
Waiting on me down there. Yeah. Isn't crazy? You never want to.
What's that?
All rise.
All right. All right. I was gonna blow my nose on the bench. All right. So, all right. So Mr. Van Horn, you're satisfied with Mr. Malaro and the advice that he gave you, correct?
Yes, ma'am.
All right. So there's an agreement on the record, but neither the prosecutor or the defendant or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Your Honor.
Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Van Horn, is that correct as far as you're aware?
Yes, ma'am.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial if the prosecution or prosecutor in court agree. You can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Did you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Van?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, sir?
No, ma'am.
All right. How do you wish to plead to the charge that on or about May 25th of 2022 in Woodstock Township in the county of Lenawee, that you did commit the offense of controlled substance possession of methamphetamine? Guilty or not guilty?
Guilty.
Now, how do you wish to plead to the charge that on that same date in Woodstock Township in the county of Lenawee, that you did commit the offense of improper transportation of a weapon? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
All right. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro
No, Your Honor.
and Mr. Sneed?
No, thank you, Your Honor.
All right, so real quick from the jail, I will not need Mr. Rembert today because they did file a waiver.
Okay.
So, I took him, so I'm gonna guess, do I have Ron Underwood? No. So I could do I could have Barry White brought in.
Okay.
All right, thank you.
Yep.
Has anybody made any threats or promises to you to induce you to plead guilty to these charges, Mr. Van Horn?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Do you understand that? All right.
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Mr. Sneed?
No, thank you, Your Honor.
All right, has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Van Horn?
No, ma'am.
Your Honor, for the
All right.
record, we did have a brief discussion about it, but I made no representations of a specific plea. Is that correct, Mr. Van Horn?
That is correct.
I'm sorry, specific sentence.
Okay. All right, so, and it's your own choice to plead guilty, Mr. Van Horn?
Yes, ma'am.
All right, so Mr. Van Horn, on May 25th of 2022, were you operating a motor vehicle in Woodstock Township in the county of Lenawee?
Yes, ma'am.
All right, and at that time, did you have in your possession methamphetamine?
Yes, ma'am.
Did you have a legal right to possess that methamphetamine?
No, ma'am.
And you knew it was methamphetamine?
Yes.
Okay, and you intended to possess it, correct?
Yes, ma'am.
All right. Now, you also had a pistol in the vehicle, is that correct?
Yes, ma'am.
All right, and where was that pistol located?
Driver's seat floorboard.
Okay, all right, and Mr. Malaro, you want to help with that one?
Yeah, sure, Judge. So in the Woodstock Township, Leonard County, Lenawee, State of Michigan, Mr. Van Horn, this pistol was not in a locked box. It was not properly secured, yes?
No, it wasn't.
Okay, and you knew it was not properly secured?
Correct.
You knew the firearm was there, yes?
Yes.
Is the state satisfied?
Yes, thank you, Mr. Miller.
All right, has court complied with MCR 6.302 B, C, and D? Mr. Malaro,
Yeah,
Mr. Steen,
Yes, Your Honor.
accept the plea that has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Malaro, are you available on April 21 at 8:15 in the morning?
I am.
You're not?
I am.
Oh, you are. Okay. So Mr. Van Horn, I'm going to set this matter for sentencing on April 21 at 8:15 in the morning. Now, Mr. Van Horn, you do have the right to be present in person for sentencing if you would like, but you can also appear via Zoom. So would you like to Zoom in for sentencing or be in person?
It'd probably be easier to zoom in.
Okay. So Mr. Van Horn, I'm going to put you in a breakout room here in a minute with, I don't know, Mr. Stevenson. And he's going to give you further instructions. When you meet with the Department of Corrections, be truthful with them about your background and also the events that occurred. They'll prepare a pre-sentence report and you'll get an opportunity to review that pre-sentence report before sentencing, like not the day of, but before sentencing with Mr. Malaro. And we'll see you back here then on April 21 at 8:15 in the morning. So Mr. Stevenson and Mr. Van Horn have opened up a breakout room. And when you're done, Mr. Van Horn, you can just disconnect and go on your way.
Okay, thank you, ma'am.
All right, thank you.
Have a
All
good day.
right, Miss, you too. Miss Bussing, you want to come on up?
Thank you, Judge.
Thank you. All right, grab Miss Bussing's files. All right, so this is in the matter of the people of the state of Michigan versus Marley Iva Bussing. File numbers 22-20954, FH 22-20955, FH 22-20956, FH. Miss Bussing, and it's not your fault. So somebody, when you got fingerprinted on one file, they didn't fingerprint you for the other files. It doesn't make sense to me, but so I am going to need you to go get those fingerprints done, okay? And let's see, 955556. Let me see what this is with. So it's the sheriff's department. So I think you can just, when you're done here, hop over to the jail, get those taken care of for me. Okay. Okay, let me check that one. Yep, no, one's the state police. I don't know. Miss Adams, can you see if the jail would do the fingerprints for that file too?
Yeah, I'll just send both orders over there.
Okay, so we'll try to do that. So hold on one second. So Miss Van Dusen represents Miss Bussing, and I have Isaac Sneed on behalf of the people. And this is file number 22-20954 FH, 22-20955 FH, 22-20956 FH. This is a date time set for a pretrial. So Miss Van Dusen, how do you wish to proceed?
Your Honor, Ms. Bussing is going to plead guilty to file 2220956 to just count 2. Count 1 and 3 will be dismissed. And then it is my understanding there'll be a noli pros for file 22-20955 and 22-20954.
Is that correct recitation of the plea, Mr. Sneed?
It is, Your Honor. Thank you.
All right, let me write that down. All right, so Ms. Bussing. Right, Ms. Bussing, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, so Ms. Bussing, this is the date and time set for a final pretrial, and you're actually set for jury trial tomorrow. Do you understand that? Now, your attorney has stated that, we've heard the statement of your attorney, the prosecuting attorney, and it's my understanding that file number 22-20956FH, you're going to plead guilty to count 2 motor vehicle operation without security. Is that correct? All right. Now, do you understand that carries a maximum penalty of up to 1 year in jail, not less than $200, no more than $500? Do you understand that? So is Mr. Sneed and Ms. Van Duzen, because under the changes in the courtroom, I'm taking more misdemeanor pleas now. And, you know, unfortunately, I don't have a lot of information on these. Is this a probation term or is this like fines and costs?
It's usually just fines and cost on this. She's going to be on probation on another case anyways, downstairs.
People have no objection to fines and costs, Judge.
All right, so Ms. Adams, would it be possible to ask Ms. Spade what the fines and costs would be on count 2, or ask Mr. Coast?
Okay.
I don't know if you need to print off the felony information. It'd be count 2. Okay, all right. So I swore you in, right? So do you, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any possible sentence with the court other than we're going to do fines and costs now, right? Okay. Now, do you understand if a guilty plea is accepted, there will be no trial? This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them, and in fact, you are set for a trial tomorrow. So do you understand that you have a right to a speedy public trial by jury? You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that? And Ms. Adams, I'll need appellate paperwork too. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? If you're not a citizen of the United States of America, the conviction could result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? Okay. How do you wish to plead to the charge that on or about July 14th of 2021 and Mr. Sneed?
Yeah, I just saw that, Judge. It'd be in Adrian Township.
Okay, in Adrian Township in the county of Lenawee, that you did commit the offense of motor vehicle operation without security. Okay. Has anyone made any threats or promises to you to induce you to plead guilty on this charge other than what's placed on the record? All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Okay, can you speak up a little bit? Sorry, you're very quiet. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Steen,
No, Your Honor.
Ms. Van Duzen?
No, Your Honor.
Okay, you already talked about what your sentence is. So is it your own choice to plead guilty?
Yes, ma'am.
All right, so ma'am, on July 14th of 21, and we said it was Adrian Township, Mr. Steen, is that what we said earlier?
Yes, Your Honor.
Okay, were you operating a vehicle in Adrian Township?
Yes, I was.
Okay, and did you not have security on that vehicle?
No, ma'am, I didn't.
Okay, and you knew that?
Yes, ma'am.
Okay, you were operating the motor vehicle anyway?
Yes, ma'am.
Okay, are you satisfied with the plea, Mr. Steen?
Yes, thanks, Judge.
All right, has the court complied with the MCR 6.302 B, C, and D, Mr. Steen?
Yes, thank you.
Ms. Van Duzen?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. So at this time, Ms. Van Duzen, we're going to proceed to sentencing. Is there anything you'd like to say on behalf of your client?
No, Your Honor.
All right, so Ms. Bussing, can I ask you a couple questions? So are you currently employed?
Not yet, but I've been looking for jobs every day.
Okay, all right, and how many people live in your home?
I like 3 or 4 people.
Okay. All right, is there anything you'd like to say before the court passes sentence?
No, ma'am.
All right. So. All right, so what I'm gonna do in this case is order a $200 fine, $50 in state costs, and $75 crime victim rights fee, all right? I'm gonna waive court costs because you're not employed at this time, and I'm somewhat familiar with you, so I think that would be a financial burden for you at this time. So, so you're gonna need to pay that through district court. Now, you do have the right to appeal your sentence. So my staff is gonna bring in your notice of right to appellate review. We'll have the initial and date the first page, and that's for my records, just to let me know that you received it. And then the other 2 are for you, and if you wish to appeal your sentence, you would fill out information on the form and mail it to the address on the form within 42 days, all right? So why don't you have a seat right there, and we'll get that paperwork for you. You're welcome.
I'll feel better.
Yeah, I finally got an antibiotic. I'll be all right. Yeah. We just tough it out, don't we? All right, so. Still, I'm gonna need you to go over to the sheriff's department. Get those fingerprints done, all right? Okay. So we'll bring that over, and I just need you to sign it. You'll be all set. All right, who do I have from the jail, please? I have a gentleman at the jail. What's your name, please?
Oh, Barry White.
All right, Mr. White, let me see here. Let me find you. Just a second, I'm here on my list. Good luck, Ms. Bussing.
Thank you.
All right, Mr. Malaro, Ms. Brenner. All right, Mr. White's file. All right, this is in the matter of people of the state of Michigan versus Barry Alonzo White. File number 20-19871H. I have Salvatore Malaro appearing on behalf of Mr. White. And I have Sarah K. Brenner appearing on behalf of the Attorney General's office. Ms. Brenner, are you able to zoom in, or you want me to pass this one?
I'm here, Judge.
Okay, so this is the date and time set for a pretrial in this matter. So, Mr. Malaro, how do you wish to proceed?
Judge, may I have a breakout with Mr. White to discuss a plea?
Yeah, so Mr. White, I am gonna open up a breakout room.
Okay,
I'm going to assign you and Mr. Malaro. So when you get that invitation, go ahead and join that breakout room. All right, what is your name? Young lady in the back,
I'm just waiting to see if someone watch, see somebody go for it.
who is it?
Christine Kramer.
Okay. All right. All right, let me see, this was. All right, I have a young man with a beard on a Samsung device. What is your name, please?
Brandon Brigman.
That one's mine too, Judge.
And
Great.
mine as well, Your Honor.
Okay. All right.
Okay. Hello?
Hi, Mr. Loomis. We'll be with you in a minute, all right?
Okay, no problem.
Okay. All right, this is in the matter of the people of the state of Michigan versus Brandon Ty Brigman, file number 21-20566FH. I am Rhonda Underwood, appearing on behalf of Mr. Brigman, and I have Sarah Brenner appearing on behalf of the Attorney General. This is the date and time set for a pretrial conference in this matter. So, Ms. Underwood, how do you wish to proceed?
Your Honor, I've spoken with Ms. Brunner, and I've also spoken with my client. I believe, Your Honor, we're close to a resolution on this, but I would like, and Mr. Brigman is paying well. I would like one adjournment just so we can firm that up. Probably not too long, Your Honor, if that's okay with Ms. Brunner.
And Your Honor, what I've offered is, even though his arrears have grown since the time I authorized the warrant, he still owes only $5,000. He doesn't have a prior record, and he is making consistent payments at this point. So what I would offer is he could plead to an attempted failure to pay with a delay of sentence, continue to pay as ordered, and if he paid the balance off in the next year, I would drop it down to a misdemeanor disorderly person. So that's the record that, or the offer that I've discussed with Ms. Underwood that she needs to finalize with Mr. Brigman.
That's fine. All right, so, all right, so my next pretrial I have available is April 26th at 8:30 in the morning. Ms. Underwood, is that all right with you?
That's fine, Your Honor.
And we have had some trouble with Mr. Brigman appearing a couple of times. So Mr. Brigman, make sure you do appear on that April 26th date, okay?
Absolutely.
All right, so write it down, write it on your hand, whatever it might be, April 26th at 8:30 in the morning. And we'll send a notice out, Mr. Brigman. I'm not going to ask you to put your full address on the record, but are you still on Medina?
Yes.
Okay, so notice will get mailed out to you. All right, we'll see you back on April 26th at 8:30 in the morning. Thank you, Mr. Brigman.
Thank you.
Your office will send out a notice, Your Honor?
No, actually, you will. You'll send a notice to him. I'm sorry.
I was
So,
gonna
Ms.
say,
Underwood,
say,
you'll do the stip in order and sign with Ms. Brenner's name.
I will be happy to
Yep,
prepare
that's
the
fine.
stip in order, Your Honor.
Thank you.
All right. Okay, thank you, Mr. Brigman. You're all set.
Thank you, Your Honor.
All right, thank you. All right, Mr. Malaro, bring the jail back.
Sam, I don't have any absconding charges on him and I won't file any.
Okay, thanks.
All right, so Mr. Malaro, we're back on the record in the matter of the people of the state of Michigan versus Barry Alonzo White. Mr. Malaro, I also have motion affidavit and bench warrant in the file for failure to appear for a circuit court pretrial on February 3rd. of 2021. So Mr. Malaro, Ms. Brenner did state on the record that the Attorney General has not filed an absconding. So how do you wish to proceed with Mr. White today?
Your Honor, at this time, I believe Mr. White's going to enter a plea of guilty to count one as charged. The supplement will be dismissed, and as Ms. Brenner has so graciously indicated, would not be seeking a warrant for absconding. I
That's
believe
correct,
that
Your
is
Honor.
our agreement.
Okay, hold on a second. All right, so you guys hold on for one moment. Let me skip over to Mr. Loomis. All right, so this is in the matter of the people of the state of Michigan versus Travis James Loomis, file number 2017-18607 FH. Mr. Lewis, this is a date time set for a request and warrant summons for probation violation. Mr. Loomis, you are currently on probation with Michael Stevenson, and paperwork has been issued stating that you have violated the articles of your probation, and that you failed to pay $2,120 that are owed to the court. Part of that is $792 in restitution, that your probation ends on November 1 of 2022. We, Mr. Stevenson, looks like we've been adjourning this, or no?
Yes, we have.
So has he made any headway?
He still owes $792, and then he can update you. He's got tax money coming back, he stated, but he still owes the $792, and he has some information for you.
All right, so Mr. Loomis, so you have your income tax return coming back.
Yeah, I have my federal and state coming back. They said 21 days. That was on March 1st is when it was all accepted, and it was supposed to be 21 days out.
Okay, and you'll be able to pay off the balance?
Yes, I'll be able to pay off the balance completely.
All right, so Mr. Loomis, what I'm gonna do is set this out to April 26th at 8:30 in the morning.
Okay. Same as last time. If I pay it, Mike can end the court date.
Oh, yeah, yep, Mike has that authority. So April 26th at 8:30 in the morning via Zoom. Obviously, if you pay off the balance, Mr. Stevenson can terminate you and cancel that date, all right?
Alrighty, that'll be perfect. I'll have it paid off.
All right, we will get a notice out to you. Thank you, sir.
All right, thank you. Bye.
Bye-bye. Okay. All right, so I'm back with you now, Mr. White. All right, so Mr. Malaro, you said he's gonna avail himself of the plea, and what is the plea?
Plead to count one, judge is charged. The supplement will be dismissed, and the Ms. Brenner, as so graciously indicated, will not seek an absconding warrant. And he will be pleading guilty to the contempt failure to appear.
Okay. All right, Mr. White, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Can you state your full name for the record?
Barry Alonzo White.
All right, so Mr. White, you have heard the statement of your attorney and the Attorney General is that your intention to plead guilty to count one, child support failing to pay, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine.
Yes.
Okay, now are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, I am.
Neither the prosecutor, the Attorney General, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
Ms. Brenner?
That's correct, Your Honor.
And Mr. White, as far as you're aware, is that correct?
Yes.
All right. Now, is it also your intention to plead guilty to the contempt of court for failure to appear back on February 3rd of 2021?
Yes.
Now you understand the maximum penalty for contempt of court could be up to 93 days in jail and or a $7,500 fine. You understand that?
Yes, I do.
Okay, now, if a guilty plea is accepted, there will be no trial. Hold on. That means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have a right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you?
No.
How do you wish to plead to the charge that on or about the time period between March 1 of 2016 through December 31 of 2018 in the city of Adrian in the county of Lenawee that you did commit the offense of child support failing to pay? Guilty or not guilty?
Guilty.
Now, how do you plead to the contempt of court charge that you failed to appear for a circuit court pretrial on February 3rd of 2021? Guilty or not guilty?
Guilty.
Okay, has anyone made any promises or threats to induce you to plead guilty to these charges?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Ms. Brenner?
No, Your Honor.
All right, Mr. White, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes.
All right, so Mr. White, you have a child with a woman with the initials of KP, is that correct?
Yes.
All right, how many children? Just one?
Just one.
Okay, and a child support order was put in place where you were to pay a monthly child support amount, is that correct?
Correct.
All right, and during the time period of March 1 of 2016 through December 31st of 2018, did you make that full monthly payment every month during that time period?
No.
Okay. All right, and you were also ordered to appear in this court for a pre-trial back on February 3rd of 2021, is that correct?
Yes.
Did you appear in court that day?
I did not.
Okay, all right, has the court, are you satisfied, Ms. Brenner?
Yes, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro?
It is.
Ms. Brenner?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the Attorney General, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence report. I'm going to set this matter for sentencing on April 21st at 8:15. Now, Mr. White, you have the right to appear in person for sentencing, or you can Zoom in like you are today. So do you want to come in person or would you like to appear via Zoom?
Via Zoom.
Okay, so we will do that sentencing via Zoom. And so Mr. White, someone from the probation department is going to come over and meet with you. They'll ask you some questions, be truthful with them about your background and the events that occurred. They'll prepare a pre-sentence report. Mr. Malaro will review that with you in advance of sentencing. We'll be back here via Zoom for sentencing on April 21 at 8:15. All right.
Okay.
All right. Thank you both.
Thank you.
Thank you, Mr.
Judge.
White.
Your Honor, may I ask the court a question?
Yes.
Did Mr. Silly get writted from prison?
Say it again.
James Silly is on your schedule? Was he
Yes.
writted out of, was there a writ for him?
Mr. White, you're all set. I don't know. Let me look. All right, I have a stipend order to adjourn the pre-trial. I have a people's writ of habeas corpus from November for December, but it looks like we do not have a writ through the prosecutor's office for today.
Okay, I mean, we have a plea we're gonna put on, so as soon as we can set him up for a court, we can get that done.
All right, so Miss Meir, can you make a note that we need a writ, and I'm gonna set this out.
Yeah, I'll send an email to Kim and make sure we get one done. Since we know what's gonna be played, do we want to put it on a non-Wednesday or just keep it on a Wednesday?
Hold on, let me call the case real quick. So this is in the matter of the people of the state of Michigan versus James Robert Silly, Cilley, file number 22-21121FH. Salvatore Malaro appearing on behalf of Mr. Seeley, and I have Phoebe Meir appearing on behalf of the people. Mr. Malaro is P42566 and Miss Meir is P81059. I have a couple Wednesdays where I don't, MDOC is really good about when they get a writ, they'll pop in right away. So I could actually set this out for April 26th. I don't have a whole lot on the docket.
Okay.
Or April 19th.
Sooner the better, Judge, as far as I'm concerned.
All right, let's do April 19th at 8:30 in the morning.
Okay, and I'll make a note to follow up with Kim about that writ, and we can prepare the stipend order too.
Okay, thank you. And here. Okay, all right, so we'll be back on Mr. Seeley on April 19th at 8:30 in the morning. Thank you, Ms. Meir.
Would the court prefer I do the stipend order, Your Honor?
Ms. Meir said she would do it.
Okay,
All right.
no problem.
Okay, so I have somebody on an iPhone.
Thank you, Judge.
No problem. I'm gonna ask you to unmute and maybe start your video. Who are you?
Elizabeth Warner.
Elizabeth Warner, Mr. Murphy.
Could I,
Be on Dawn today.
I don't know. Hold on. This is in the matter of the people of the state of Michigan versus Elizabeth Jean Warner, file number 2021-20607FH. I have Christopher Fleming appearing on behalf of the people, but do I have Mr. Murphy or Ms. Van Duzen today?
Ms. Van Duzen, I can do it, Your Honor. I got the offer. If I could have a breakout room with her, though.
All right. So, ma'am, are you able to start your video?
Yes.
Okay, perfect. Okay, so I'm going to put you in a breakout room with Ms. Van Duzen.
Okay, thank you.
You're welcome. Okay. There you go. I'll go join that breakout room. Okay, so she's here. Oh, she's in the breakout room. Brenda Underwood.
Your Honor, good morning.
Yes.
Do we have Jason Wright.
Well, I have the file, but I do not have Jason Wright. So I was just getting ready to issue a bench warrant. So let me call the case. This is in the matter of the people of the state of Michigan versus Jason Scott Wright. Jason is with an I. File number 22-21032FH. This is the date and time set for a pretrial. I do have a stipulation in order in the file setting it for today. I have Ron Underwood on behalf of Mr. Wright and Phoebe Muir appearing on behalf of the people. So, Ms. Underwood.
Well, Your Honor, I spoke with Mr. Wendt from the Economic Crimes, and Mr. White was supposed to be doing diversion, and that has not been done, Your Honor. So I'm a little concerned, and I have not been able to reach Mr. White by telephone.
I guess I'll have to go find him for you. So what's the?
So if we could have, if the court is going to issue a bench warrant, if we could have a 48-hour grace period, that would be appreciated.
Well, by statute, you can't issue the bench warrant for 48 hours anyway. So that's a new change. So, but I will hold it for 48 hours. So defendant failed to appear, may issue a bench warrant after 48 hours, and I will set bond in the amount of 40,000 cash assurity. And obviously, Ms. Underwood, if you're able to reach him, we would love to see him.
And the only thing I'll add is that his last contact with Mr. Wendt for diversion was November 28, 2022.
All right. Okay. All right. So Ms. Underwood, that takes care of that one.
Thank you.
Dawn,
Yes.
Ms. Underwood, are you under?
Can
are
I
you
talk
still-
to you
are
again?
Ms. Van Dusen, she would like to go in the breakout room with you again.
Okay, I can do that.
I'm gonna open that breakout room again, go back in. Ms. Underwood, you represent Marlowe on a PPO show cause, is that correct?
I do.
You're not here for that one, right? Ma'am, in the gallery? I'm waiting for Christie. Okay, so this is in the matter of Patty Marlowe, M-A-R-L-E-A-U versus Adam Marlowe, file number 22-49798 PP. This is the date and time scheduled for a show cause. Let's see, on August 9th of 22, this court issued a PPO, which remains in effect to August 20th of this year. It was served on August 18th of 22. There's an allegation that he violated the personal protection order on August 19th of 2022. So, let's see something. Let's see, we faxed notice. I don't know that I have. Proof of service for today. Looks like I have a certificate of mailing for the August 30th date back on August 25th, because we faxed his notice to the jail. And that gave him notice to appear for August 30. And he signed his pretrial services conditions. And then there's the new violation, but I don't have a proof of service in the file. Do you have one, Mr. Steen?
No, Your Honor, we emailed the order setting today's date to the agency back on February 7th. However, we don't have any return of service with any attempts at service at this point.
All right, very good, thank you. Okay, so we can reschedule that when you get notice, all right. Ms. Van Duzen, we're back with. Who is this again, Ms. Van Duzen?
This is Miss Warner.
All right, this is in the matter of the state of Michigan versus Elizabeth Jean Warner, file number 21-20607 FH. And Dawn Van Duzen appearing on behalf of Ms. Warner and Mr. Fleming appearing on behalf of people. So let me find her on my docket. Somewhere she's right here. All right. So this is a date time set for pretrial. Ms. Van Duzen, you asked to speak with your client. Are you ready to proceed?
Yes, Your Honor. Miss Warner will be pleading today to a 1-year misdemeanor. And it's Mr. Fleming's case. Do you want to put the plea agreement on the record, Mr. Fleming?
I believe it should be pleading to an attempted financial transaction device use of revoked or canceled to obtain goods $500 or more. That's under 750.157S. Subsection 1, subsection C, Judge, that is a 1-year misdemeanor. In return for that, there is an agreement that the defendant shall pay restitution in the amount of $1,000 by the time of sentencing. If that is done, defendant shall receive a delayed sentence. If that is not done, sentencing will commence.
That is correct, Your Honor.
Okay, so is that going to be account 2?
It will be an added count too, and I'll need to get an amended info, Judge.
And what's the charge called again?
It's an attempted financial transaction device use of revoked or canceled to obtain goods $500 or more.
Okay, cancel. And you said it's a 1-year misdemeanor?
It is, Judge.
Okay. All right, is that right, Ms. Van Duzen?
It is correct, Your Honor.
All right, so Ms. Warner. There you go.
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to an added count 2 attempted financial transaction device revoked or canceled, which carries a maximum penalty of up to 1 year in jail? Is that your intention to plead guilty to that count?
Yes, ma'am.
Now you understand there's an agreement that if you pay $1,000 in restitution by sentencing, you can receive a delayed sentence. Do you understand that?
Yes.
If you don't pay it by sentencing, you won't receive the delayed sentence. Do you understand that?
Correct.
Okay. All right, Ms. Adams, if I could get, I could do from the jail, Jay Klein or John Gonzalez. Okay. Are you satisfied with Ms. Van Duzen as your attorney and the advice that she has given you?
Yes, ma'am.
Other than the agreement placed on the record, neither the prosecutor, the defendant, nor anyone on their behalf has discussed any other possible sentence with the court. Is that correct, Mr. Fleming?
That's correct, Judge.
Ms. Van Duzen?
That's correct.
And Ms. Warner, is that correct as far as you're aware?
Yes, ma'am.
Okay. All right, can you like sit still and hold this phone still? Because I kind of get vertigo when people are like wandering around. Okay. All right. So do you understand if a guilty plea is accepted, there will be no trial? Do you understand that?
Yes.
This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You have a right to have the prosecuting to be present at a trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that?
Yes, ma'am.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you?
No.
Ma'am, how do you wish to plead to the charge that on or about June 26th of 2021 in the village of Clinton in the county of Lenawee, that you did commit the offense of attempted possession of a financial transaction device that was revoked or canceled? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
All right. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fleming?
No, Judge.
Ms. Van Duzen?
No, Your Honor.
Ms. Warner, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes.
You were in fact scheduled for trial on March 14th, actually next week at 9 a.m. Is that correct?
Correct.
All right. So Ms. Warner, on or about June 26th of 2021, were you in the village of Clinton in the county of Lenawee?
Yes.
And at that time, did you have in your possession a financial transaction device that had actually been canceled or revoked?
No.
Okay, Miss, all right. So did you have a debit card or a credit card from somebody?
No, neither.
All right, so Miss Van Duzen, perhaps, or Mr. Fleming?
Mr. Fleming, do you want to do it?
I can. So back on, let's see, approximately July 20th, 2021, were you at that time in the village of Clinton, county of Lenawee, state of Michigan?
Yes.
And at that time, did you make essentially an agreement with an Amanda Ormsby?
Yes.
And what was that agreement for?
So she was going to purchase my mobile home at the time. So she had gave me $1,000 check for a security deposit on the home.
Okay. And when she gave you that $1,000 check to purchase this mobile home, you didn't have any right to actually sell this mobile home, correct?
No, that was my house.
Okay. But you were not able to sell the mobile home, correct?
What do you mean? I don't understand.
Well, it was never sold to Miss Ormsby, correct?
Correct. Because she was not approved to live in the park that the house was in.
Okay. And did you refund this $1,000 deposit to her?
No.
Okay.
Sorry, it was just confusing.
And the agreement was that you would sell the home to her.
Correct.
But that was not done.
Correct.
All right.
And the only reason that wasn't done is because of the approval of being into the park.
But you still retain the $1,000 deposit, correct?
Correct. Yeah. Because
Huh.
she was
And you
told
should-
already that she was approved, and then 2 days later. Yeah.
But you should have refunded that $1,000
Correct,
to her, correct?
Correct.
All right. People are satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Fleming,
You have, Judge.
Ms. Van Duzen?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set sentencing in this matter for April 21 at 8:15 in the morning. Now, Ms. Warner, you do have the right to be present in person for sentencing, or you can appeal via Zoom. Are you there, Ms. Warner? Because all I
Yeah,
saw
I'm
was
here.
that-
Sorry, I was writing it down. Sorry, I'm here.
Okay, so you can be present in person or via Zoom. Do you want to appear in person or via Zoom?
Zoom's fine.
Okay. Now, I'm gonna put you in a breakout room with Mr. Stevenson from the Michigan, or no, I'm not, it's a misdemeanor. So Ms. Warner, tomorrow morning between 8 and 10, I need you to report to the district court probation department. All right? And
Okay,
check in,
okay.
give them their name, because this is a misdemeanor, so it would be through district court probation. So go to the first floor of the courthouse, check in at district court probation between 8 and 10. They'll give you instructions, make sure you comply with them, meet with them, and we'll see you back here on April 21st at 8:15 in the morning. We'll provide Ms. Van Duzen a copy of the pre-sentence report to review with you before that day, and we'll see you then. All right?
Okay, thank you so much.
All right, thank you.
Have a good day. I hope you feel better.
Yeah, I will, thanks, you know. All right, so. I think everybody I have left is in jail. All right, all right, Ms. Brenner, and who has Mr. Klein? Who represents?
I think it's Rhonda.
I don't think I have Rhonda. I don't have Rhonda
Go.
anymore. So Mr. Klein, I had Rhonda Underwood earlier, but I don't have her right now. So Mr. Klein, is it all right if I ask them to take you back and take care of somebody? Let me see what else I have. I have actually Rhonda and everything. We took care of Dotson, right? Okay, hold on a second. Olmsted, that's yours, Ms. Van Duzen?
Yes.
All right, in the matter of the people of the state of Michigan versus Harley Olmsted, file number 22-20693FH. I have Don Van Duzen appearing on behalf of Harley Olmsted, and I have, hold on, Mr. Klein, just give us a minute.
Okay.
What were you gonna say, Mr.
I was
Klein?
gonna ask if you wanted me to go back then.
No, you might as well stay. So,
Alright.
Don Van Duzen appearing on behalf of Harley Olmsted, and I have Isaac Sneed appearing on behalf of people. This is a date time set for pretrial. I do have proof of service and notice to appear that was mailed out by my staff on January 18th for notice for today, and it was given personal service placed in the hand of Harley Olmsted in the courtroom. So we do have valid service for today's hearing. Ms. Van Duzen.
Yeah, and I've been trying to call him since January 25th, and he has not returned any phone calls.
All right, so we will issue a bench warrant for is Harley a boy or a girl?
A boy.
He's booked.
A man, he's a man. All right, so we'll issue a bench warrant for Mr. Olmsted, and I'll set bond in the amount of 50,000 cash as surety. And obviously, if you're able to reach them, Ms. Van Duzen. I would love to see him. Okay. Mr. Fry, who are you hearing?
Zachary Ladd, Your Honor.
All right, so Mr. Klein, why don't you let them know that your attorney is not with me yet? So could we see Mr. Ladd instead?
Yeah, I'll tell them. Thank you.
All right, thank you.
Your Honor, I have Jamie Todd and she's in the waiting room.
No, she's not. Who is it?
Jamie Todd?
That's Judge Savers. I think that the only cases I have left are Zachary Ladd, John Gonzalez, Jake Klein, and Christine Kramer. That's it. I think I'm done with you, Ms. Van Dusen.
Okay, yeah, those look like Kramer's is Mr. Glazier. So, okay,
Yep.
I'm gonna go into the next courtroom then. Thank you, Your Honor.
All right, I'm gonna step off the bench for a couple minutes. It's one of these restrooms you can't.
All rise. He's not here yet.
Do you know if she went back to her office? I'll go look, you can. I'm gonna get you. Okay. That's not good. So.
Ran over to third, right, to the family shop. You got the great lake map of yeah, you know. No, yeah, they were about 1,000 different matches. Yeah. Oh. Yeah. Darren, yeah. Feel like we're on Titanic. Oh, there, 2 or 3. Oh, you be. 34, coming. Yeah, oh, yeah. Good delay is. Oh, we're scared. Yeah. Oh.
Now I get Brenda Underwood. All right, Becky, now I have Brenda Underwood back, so I guess I can take Mr. Klein. But, Miss Brenner,
Yes, Your Honor.
I'm gonna put Rhonda and you into a breakout room with my staff, and I'm gonna go back and talk to you for a minute.
Okay.
Gotta move.
Yeah.
Getting too old.
Okay. Yes, sir. All rise.
All right, so. All right, Mr. Klein, hold on a minute. Your attorney is talking to the Attorney General. So we'll be back in.
Yes, ma'am.
Mr. Malaro, I don't show anything else to you, or do I?
That's correct, Judge. I'm just hanging around because I like it here. Actually, I have the intern with me and I'm trying
You're the
to
intern? Is that what you just
learn
said?
her.
All
Yeah,
right, I didn't know if you were just monitoring to make sure I don't abuse any of the attorneys or anything, but,
Yeah.
all right.
would
So
encourage
we
you
are
to
on the
abuse them.
record in the matter of the people of the state of Michigan versus Jake Gordon Klein. We have three files. On file number 22-20712FH. I have Sarah Brenner appearing on behalf of the Attorney General's office. And I have Rhonda Underwood appearing on behalf of Mr. Klein. On file number 2023-21223FH and 23-21224FH. I have Rhonda Underwood appearing on behalf of Mr. Klein, and Phoebe Meir, is my understanding, appearing on behalf of the people. Is that correct, Ms. Meir?
That's correct.
All right, Ms. Meir, I did have a breakout room with Ms. Brenner and Ms. Underwood regarding their file, but it wasn't regarding yours.
Okay.
Your
Okay,
Honor, may I have a breakout with Mr. Klein just briefly?
of course. So.
Can I have one with Miss Muir while they're in there, Judge?
Sure. All right, so I'm gonna put Miss Brenner and Miss Meir into a breakout room. And then I'm gonna put Miss Underwood and there. All right, so I'm opening all those breakout rooms.
Thank you.
You're welcome.
I'm trying to roll up this yarn ball and I keep dropping it and then it rolls across.
Have you seen I think they did them at our Adrian Center for the Arts. You can buy the clay bowls that have the thing in them to put the yarn in. It's kind of cool.
Yeah, I'm not that sophisticated yet. I'm still a newbie.
All right, so let me bring the jail back in. So is this a different jail room on a different floor?
Yeah, this is
Sergeant?
in booking. This is in booking if you want to see Mr. Ladd.
Okay, yeah. I'm ready for Mr. Ladd.
Okay.
Thank you. All right, so back on the record in the matter of the people of the state of Michigan versus Jake Klein. So Ms. Underwood, you've had an opportunity to speak with Mr. Klein.
I have, Your Honor.
Right, and Ms. Underwood, how do you wish to proceed today with Mr. Klein?
Your Honor, I think at this point, I want to set this matter for trial, but Your Honor, we would like to keep the plea bargain open, and I've assured Mr. Klein that if we can resolve some issues, that we will come in and take a plea bargain, if it's acceptable, at the earliest opportunity. I know Mr. Klein has been in jail, I believe, like 3 months, and these are 5-year felonies, Your Honor, so.
Have you
and
run
he
his
has very
guidelines,
little
Rhonda?
record.
Rhonda, have you run his guidelines at all?
I have not run them. I can't imagine they're going to be very substantial at all.
Okay.
All right, so he does have 3 files. So we have 2-month panels. So the first matter that would be set for trial would be the felony child support case. Ms. Adams, I'm looking for a 1-day jury trial.
Okay.
Do you want a jury or a bench trial on the child support, Rhonda?
We'll do jury, Sarah, for now.
Okay. Okay.
Yeah.
And just whenever you want me to, I can weigh in on my cases.
Okay, so what I would do, Ms. Meir, because they would be moved to the next panel, I would actually just set the oldest file, which is Ms. Brenner's, for trial, and then set them all for a final pretrial.
Okay.
But I wouldn't give you a trial date on yours yet.
Okay.
Judge,
The only
Is that all right?
thing, as it relates to mine in trying them, there's a lot of different witnesses, and it's going to take a lot of prep. So I would withdraw my offer at least 30 days before our trial, whenever it gets set. And then I would be doing a motion to consolidate unless there's a stipulation to that consolidation.
Okay. Ms. Adams?
Yes, we did have an opening on April 18th. I don't know if it's too soon. It's a Tuesday.
April 18th.
Yes.
All right, Mr. Ladd, do you not have a shirt?
Yeah, can you give me a shirt?
Would that be 9 a.m.? Oh, you got a vest. Okay,
Yes.
put your vest on. What time, Ms. Adams?
It's a Tuesday, so yes, 9 a.m.
Jake Klein, what's up, bub?
Okay, so, all right, so Mr. Klein, I'm gonna set your one case, because it's the oldest file, for trial on April 18th of 2023 at 9 a.m. I'm gonna set a final pretrial on all your files for April 12th of 2023 at 8:30 in the morning. Mr. Klein, I'm going to also set that as the motion deadline. The date jury instructions and voir dire questions are due for the April 18th trial. Now, Miss Underwood, obviously, if you reach some type of resolution, we will accommodate you, and I'm going to be out of the country for a period of time, but Judge Olsaver would also accommodate any pleas as well. All right.
Yes, Your Honor, and I understand Mr. Klein's concerns, and I understand the court's concerns, and I'm going to try to do that at our first opportunity, Your Honor.
All right, so Mr. Klein, I will see you back on April 12th at 8:30 in the morning for a pretrial. But then, as I said, the child support case is set for jury trial on April 18th at 8 a.m. All right.
Yeah.
All right, thank you, Mr. Klein.
Thank you.
All right, Mr. Fry, I do have Mr. Ladd. Let me grab his files. All right, this is in the matter of the people of the state of Michigan versus Zachary Lawrence Allen Ladd. File number 22-21116 FH. I have Brian Fry appearing on behalf of Mr. Ladd, and I need a prosecutor. I'll take Mr. Fleming appearing on behalf of the people. Let me find this file. Here we are. So, Mr. Fleming's name in there. All right, Mr. Fry, this is the date and time that's set for a pretrial. How do you wish to proceed today?
Your Honor, if the court would be willing, it'd be our request for another pretrial. Mr. Ladd has 2 new felony cases that are pending in district court right now. I believe his preliminary examination is scheduled for March 24th. That would give us an opportunity to see if those do get bound over or not. And if they do, we can combine all these cases. And if not, we can just resolve this one.
All right, March 24th. So I will set this for another pretrial on April 12th. So Mr. Fry, if he's being bound over on the 5th, if you just call Miss Adams and do a stip and order, we can move them all together.
Thank you, Your Honor.
And
Thank you,
maybe April 12th, I'm not sure. So, all right, so I'll set another pretrial, April 12th, 2023 at 8:30 in the morning. And Mr. Fry, you do the stip and order to adjourn.
I can do that, Your Honor.
All right, and Mr. Fleming, can you sign your name and permission?
You can, Judge. Thank you.
All right, Mr. Ladd, you are all set, and I'll continue your not guilty plea. Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you, Mr. Fry. All right, so it appears we have so Miss Adams, I need John Gonzalez from the jail.
Okay.
Your Honor, is Miss Teskey in today? Do you know?
She is in the building, but she is not in Zoom. Number is 4592.
4592?
Yes, ma'am.
Or number 2 there, John.
All right, Mr. Gonzalez.
Yes.
All right, this is in the matter of the people of the state of Michigan versus John Alex Gonzalez. We have 3 files. File number 20-20024FH is a probation violation hearing. File number 22-20806FH is also a probation violation hearing. And then we have file number 22-21188FH. Doesn't say. That is a new file set for pretrial. So Ms. Underwood represents Mr. Gonzalez, and I believe I have Phoebe Muir on this file. Is that correct?
Yes, sorry, Your Honor.
It's okay. And I have Phoebe Muir appearing on behalf of the people only on the final pretrial file. The other ones are violations with no prosecutor. So Ms. Underwood, how do you wish to proceed today?
Your Honor, I've spoken to Mr. Gonzalez, but I just want to speak to him again briefly. Okay?
Yes. All right. So Mr. Gonzalez, I'm going to open up a breakout room and close them up quick. And I'm going to assign jail. All right. You said Kramer here, right? Sorry, it's going to turn out to be the last one. I apologize. It's okay. We're always live on YouTube if you don't want to come into the courthouse. Yeah. So you can always watch it on YouTube. I didn't know that, but thank you. We started doing that with the pandemic because to provide access to the courts, and it seems to be a good thing. It educates a lot of people in the public, and it seems to work. I don't know.
Your Honor,
Yes.
I think I've bored the intern to practically sleeping, so I'm gonna log off now.
All right. Well, I'm glad I'm effective.
Oh, she was interested in you, it's just me, I'm just so boring.
All right. Bye, intern.
Bye.
All right. So I just closed the breakout room. The jail back. That's it. All right, so we are back on the record, Ms. Underwood, with Mr. Gonzalez. So how do you wish to proceed today?
Your Honor, I believe the offer from Mr. Gonzalez is Mr. Gonzalez will plead to 2 counts of resisting, obstructing, and the 3rd count will be dismissed. And Mr. Gonzalez will also plead to the violation of probation, Your Honor.
All right, so Ms. Mayor, he would plead guilty to count 1 and count 2.
Yes.
Okay. All right. And the probation conditions, let me put those over there. All right, so Mr. Gonzalez, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah,
All right, can you state your full name for the record?
John Alex Gonzalez.
All right, so Mr. Gonzalez, you have heard the statement of your attorney and the prosecuting attorney on file numbers 2020-20024FH and 22-20806FH. Is it your intention to plead guilty to the violation of probation, which alleges that you violated the terms of your probation and that you were ordered on October 5 of 2022 to report to the Salvation Army Harbor Light for residential treatment, and then to report immediately to the probation upon discharge, and that on October 25 of 2022, contact with staff there indicated that you never showed up for treatment, but you were released from jail and you failed to report to probation or to the Salvation Army. So is it your intention to plead guilty to the violation on both of those files?
Yes.
Okay, so you know on file number 20-20024FH, you are currently on probation for accessory after the fact to a felony, which carries a maximum penalty of up to 5 years in prison if you plead guilty or found guilty. And then on file number 22-20806FH, you are currently on probation for, let me see here, 2 R&Os. So you understand the maximum penalty if, hold on, let me look again. You're on, all right, currently on probation for police officer R&O, 2 counts, which carries maximum penalty of up to 2 years in prison if you plead guilty or found guilty. And then also to count 5, attempted home invasion, 3rd degree, which carries a maximum penalty of up to 2.5 years in prison if you plead guilty or found guilty. Do you understand that?
Yes.
Sorry, organizing your file. All right, and then on your new file, the plea offer, is it your intention to plead guilty to count 1 and count 2? Police officer assaulting, resisting, and obstructing, which each carry a maximum penalty of up to 2 years in prison. Is that your intention to plead guilty to those as well?
Yes.
So, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
And Ms. Muir?
That's correct.
Okay. Is that correct as far as you're aware, Mr. Gonzalez?
Yes.
All right. So if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial if the prosecutor and court agree. You can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you?
No.
All right, so let's start with file number 22-211-88FH. Mr. Gonzalez, how do you wish to plead to the charge that on or about December 1 of 2022 in the city of Adrian in the county of Lenawee that you committed the offense of count 1, police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty.
And count 2, police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty.
And then on files number 22-20024FH and 22-20806, how do you plead to the violation of probation that you failed to report to the Salvation Army Treatment Center, Harbor Light, as ordered, or report to probation as ordered? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to any of these charges?
No.
Do you understand if I accept this plea, you will be giving up any and all claims? Hold on. That your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, and that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducement other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Ms. Meir?
No, Your Honor.
Has your attorney, Mr. Gonzalez, promised you any particular sentence or estimated what your sentence will be? Mr. Gonzalez, has Ms. Underwood promised you any particular
No.
sentence or estimated? Okay. Is it your own choice to plead guilty on these 3 files?
Yeah.
All right, so Mr. Gonzalez, start with the violation of probation. So on file number 20-20024FH and 22-20806FH, you were placed on probation, and at some point on or about August 11th, you signed your terms of probation. You were ordered on both of these files at different times to report to probation as often as required. Is that right?
Yeah.
Okay, now we amended your probation terms back on October 5 of 2022, ordering that you report to the Salvation Army Light for residential treatment upon discharge from jail. Is that correct?
Yeah.
All right, and then on October 25 of 2022, the probation department made contact with the staff at Salvation Army Harbor Light and were informed that you had never shown up for treatment, even though you were released from the jail to do so, and that your whereabouts were unknown. So when you were released to jail to go to the Salvation Army Light program, did you go?
No.
Okay, you could have gone, you just chose not to, right?
Yeah.
Okay, and then you never reported to the probation department as well, did you?
No. I don't do probation.
All right, so then let's move on to file number 22-21188FH. Mr. Gonzalez, on or about December 1 of 2022 in the city of Adrian in the county of Lenawee.
Yeah.
And you came in contact with 2 Adrian police officers.
A little bit more, but yeah.
Say it again.
I said a little bit more, but yeah, I did.
Okay, there were more than 2, but we're just pleading, were there like 3, 4?
Who knows?
Who knows? Okay, but would you agree one of them was Officer Mullen and one was Officer White? Would you agree with that?
Yeah.
Okay, now, at some point when you came in contact with them, did they tell you to stop and talk to them? Did they tell you to stop your car? Did they tell you to get out of the car? Did they try to take you in custody? What happened?
I mean, they showed up at my door, said I had a warrant. I told them that was my name. I tried to close the door and they kicked it in.
Okay,
Got into a
so,
scuffle.
say it again.
So I got into a scuffle with them. I didn't touch an officer, I just resisted.
Okay, so when they tried to handcuff you, you resisted, is that correct?
Yep,
All right, now you're currently on probation, which means your house and your personal property can be searched at any time. Is that correct?
that's why I don't do probation. I'm trying to max out, so it don't happen again. But that's correct.
Sometimes if you just don't run, you don't get any charges, Mr. Gonzalez. All right, so but they were, you could tell they were police officers, they were in uniform. So you knew they were police, right?
Yep,
All right, Miss Mary, satisfied?
I am, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Miss Mir,
It has.
Miss Underwood?
It has, Your Honor.
Accept the pleas, they've been given understandably, I'm so sorry, voluntarily and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department, and we will set sentencing for April 21 at 8:15 in the morning. Now, Mr. Gonzalez, you do have the right to appear in person for sentencing, but you can't appear via Zoom like you are today. Do you want to appear in person or do you want to appear via Zoom?
you can appear in person. What's the date again?
April 21 at 8:15. So you
All right.
want to be transported from the jail to appear in person?
Yes, please.
Okay. I'm gonna mark that down. All right, so Mr. Gonzalez, somebody from MDOC, probably your current probation officer, is gonna come over and talk to you and be truthful about what happened, the events that occurred, your background. They'll prepare a pre-sentence report and a probation violation report. We'll give a copy of that to Miss Underwood. She'll review that with you before the day of sentencing. Mr. Gonzalez, if you had not ran that day, you would have just been facing a violation of probation. You know that, right?
Yes,
And now you're facing more charges, which almost technically could stack if I was the type of person to do that. So, you know, you need to think about those things. All right, so we'll see you back on April 21 at 8:15 for sentencing. Thank you, Mr. Gonzalez. All right, so the last one we have is Miss Kramer, which is Mr. Glazier. I don't have Mr. Glazier.
Your Honor, what did we end up doing with Mr. Marlowe?
Mr. Marlowe?
Yes.
Mr. Marlowe failed to appear, right?
Well, I don't think there was any notice.
Oh, no, I wrote down we had no proof of service, so they'll try to serve him and bring him back.
Oh, okay, so just. Okay,
Yep, so
Thank
now I
you.
just need John Glazier. Becky, if you can let the jail know, we can take Miss Kramer.
This one says, Randy Keegan.
All right, Mr. Paul, what are you here for? I have a D Paul that's logged in. Can I ask what you're here for? Mr. Paul, can you hear me?
Yes,
Okay, can I ask what you're here for?
I'm just testing my system for a court case on Friday. That's all. I'm just gonna bow out now.
Okay, thank you. Bye-bye.
He can sit in for me, Judge.
Nice try. You're not going anywhere, Mr. Smith. All right. Well, we're just waiting on the
Voluntarily.
Joe. Huh?
I said I'm here voluntarily.
All right, we got one more. I'll be right back when I see someone come on the screen. All right, I'm just waiting on John Glazier and the Joe, so I'll check that.
You know if we have anybody already logged in? Right over here, ma'am. Christine Kramer, you're supposed to see Judge Amazon, that's all right? Yes. Okay. Okay. I didn't see the judge on the screen, but she did be back.
Okay.
Miss Kramer will be right with you in just a couple minutes.
Okay.
We're just waiting for your attorney.
Oh, okay.
Okay, thank you. Yeah, you're supposed to be married. Yeah,
All right, we got Miss Van Duzen popping in. So Miss Van Duzen, I had sent you a message because I knew that Judge Olson was meeting with different attorneys. I wasn't sure if Mr. Glazier could pop in or not.
Yeah, he can't right now, so I'll handle whatever needs to be handled.
So this is Christina Kramer, file number 23-21205FH in the matter of the people of the state of Michigan versus Christina Kramer. This is twofold. We have a pretrial conference scheduled today, but we also have a January 9th of 2023 letter from our pretrial services coordinator, Mr. Coast, as well as another one from February 22nd. On January 9th, Mr. Coast informed the court that she tested positive for meth for 4 days. After being placed on bond condition, she missed her very next drug screen. He was unable to reach her via email. She called later to say her phone wasn't working and she couldn't make it to test. And he had at that time indicated that he would try to set up in Hillsdale. And then I have a letter dated February 22nd of 2023, which states that her January 23rd screen returned positive for both amphetamines and meth. She showed up on February 17th for her test without money to pay for it. She's being tested. They made arrangements for her to test at the courthouse at a reduced rate to help her out. And it's only $10 a test when it's normally $20. She's now currently in custody, and she's in custody on the motion and order show cause dated January 23rd of 2023 for testing positive for amphetamine and meth on January 23rd in district court probation. The charges in this file are a controlled substance possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison, as well as a use of methamphetamine, which is a 1-year misdemeanor. And I think my notes say that the plea offer that was made to her was plead to a use of 7411 with no upfront jail. But so we have Dawn Van Duzen appearing on behalf of Ms. Kramer for Mr. Glazier, who's currently in another hearing, and I have Isaac Sneed appearing on behalf of the people. So Ms. Van Duzen, what would you like me to do?
Your Honor, could I have a breakout room with her?
Sure. All right, so Ms. Kramer, I am going to open a breakout room for you and Ms. Van Duzen.
Okay.
Miss Adams,
Yes.
there was a Beagle on the pickup list for violation of bond conditions. He wasn't one of ours.
They didn't bring us anything. I'll run the name though.
I swear I thought that was one of ours. All right, Ms. Van Dusen, I will close that breakout room. All right. Go back. All right, we are back on the record in the matter of the people of the state of Michigan versus Christine Kramer. Once again, I'd like to thank you, Ms. Van Dusen, for popping in to cover this. So Ms. Van Dusen, you've had an opportunity to speak with Ms. Kramer. How do you wish to proceed today?
You know, we're going to plead guilty to the contempt of court, and I'd ask for set over the pretrial to date that Mr. Glazier can be here.
Okay. All right. So, Ms. Kramer, raise your right hand, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Can you put your hand down and tell me your full name, please?
Christine Leanne Kramer.
All right. So, Christine Kramer, you've heard the statement of your attorney. Is it your intention to plead guilty to the contempt of court in this case?
Yes, I will.
All right. The contempt of court alleges that you tested positive for amphetamines and methamphetamine from a screen collected on January 23rd of 2023 in violation of your bond conditions. Do you understand that?
I do understand that.
All right, the maximum penalty for contempt of court could be up to 93 days in jail and or a $7,500 fine. Do you understand that?
I do.
Okay. Now, I know that Mr. Glazier previously was representing you and he will again, but he is tied up in the other court and Ms. Van Dusen was kind enough to pop in to take care of this matter for you.
I understand that.
Are you satisfied with Ms. Van Dusen's representation this morning and the advice that she's given you?
Yes.
Okay, all right. So, ma'am, do you understand that you have a right to contest the contempt of court charge and to have a hearing on it? Do you understand that?
I do understand that.
Do you understand that throughout the hearing, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, I do.
You have a right to have all the witnesses against you appear at your trial and have your lawyer ask those witnesses questions, or you may ask them yourself and to have me order any witnesses you might have to appear at the hearing. Do you understand all of that?
Yes, I do.
You do not have to testify at your hearing and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, I do.
On the other hand, do you understand that you do have a right to testify at your trial if you want to testify?
Yes, I do.
How do you plead to the charge that you violated your bond conditions by testing positive for amphetamines and methamphetamines on January 23rd of 2023? Guilty or not guilty?
I'm guilty.
Okay. Do you understand that by pleading guilty, you'll be giving up a right to a trial or a hearing? Do you understand that?
Yep.
Has anything been promised you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do.
And is it your own choice to plead guilty?
Yes.
All right. So, ma'am, you are currently on bond for a case that involves possession of methamphetamine. Is that correct?
Yes.
Okay. And one of your bond conditions is that you're not to use any illegal controlled substances and you are to test as directed by Mr. Coast. Is that correct?
Yes, it is.
All right. So on January 23rd of 2023, you submitted to a drug test. Is that correct?
I don't have my notes in front of me, but yes, I assume so.
Okay. And when you tested that day, you tested positive for amphetamines as well as methamphetamines. Is that correct?
I assume so, yes.
Well, you did or you didn't?
Yes, I guess. Yes. I guess I don't have my notes in front of me.
Okay, do you know that, was it because you had used methamphetamine and amphetamines?
I did not. I was actually sick with COVID then and taking all kinds of different cough medicines and different things to try to feel better, but I didn't know I had COVID. But I mean, that's regardless of the point at this point, so.
Okay, so I'm not gonna accept the plea. Ms. Van
Judge, can I-
Dusen, I'm gonna.
Judge,
Yes,
can I
Mr.
interject
Cox.
here? Also, when she appeared on February 22nd, we did do an additional test. And that was positive for meth as well, and that's when she was taken into custody.
Okay.
I
So
did.
it says we have 2 positive tests.
Okay, so Ms. Van Dusen at this time, she's not admitting to use. So what I'm gonna do is set these for a pretrial with John Glazier. Ms. Van Dusen, Mr. Glazier, Ms. Adams, do we have a time tomorrow that I could see her with Mr. Glazier? It doesn't have to be early in the morning because I know he has other things to do, but
If you want to do 11:30 after drug court.
do you think Ms. Van Dusen, Mr. Glazier would be available at 11:30 tomorrow?
Yeah, he should be, Your Honor. We go up to the conference tomorrow, but he doesn't have to be there to tomorrow night.
Okay, so I'm gonna set this over to tomorrow at 11:30, ma'am, and then we'll have Mr. Glazier here with you, okay?
Okay, okay. Can we talk about what the reduced bond today?
No. All right, so we'll see you back on March 9, which is tomorrow at 11:30 via Zoom with Mr. Glazier. Thank you.
Thank you.
Thank you, Judge.
Thank you.